The International Criminal Court is now in session.
Thank you. Good morning, everybody. Good morning, teams. Good afternoon. Good afternoon, teams. Good afternoon, everybody. My name is Eric-Aimé Sémien. I'm the presiding judge for the hearing today. And the panel is made today of Dr. Vladimir Tochilovsky and Mrs. Seoane Dalila, also judges. The hearing will oppose today the team 34 representing the prosecution and the team 67 representing the defense. So you will have the time to make your first statements, and then we'll have a rebuttal. Team 34, the prosecution, are you ready?
Yes, Your Honor. Would you like me to give an introduction of our team or begin with our submissions right away? Mr. President?
Please start by introducing your team. Can you hear me?
Yes, Mr. President.
Yeah,
Much
start by
obliged.
introducing your team.
Mr. President, Your Honors, I'm Jordan
Go
Chia.
ahead, please.
I'm Jordan Chia, together with my co-counsel, Mr. Chong Kai-sheng, represent the Office of the Prosecutor. I will address Your Honors for 15 minutes, while my co-counsel, Mr. Chong, will address Your Honors for 10 minutes. We reserve 5 minutes for rebuttal.
Okay. You're gonna start. You can start.
Okay. Thank you, Mr. President. Mr. President, Your Honors, may it please the court. The case before us today concerns one of the worst crimes known to humankind, the crime of genocide. The genocidal series of events left Castilian men shot and the Castilian race starving to death while within the confines of the Castilian state. And at the center of these atrocities lies the President and Commander-in-Chief of the Republic of Honiton, the accused, Mr. Grevas. Today, this court is not asked to pronounce on the ultimate culpability of the accused, but simply to see if there are reasonable grounds to commit this case to the confirmation of charges stage. What this requires is simply the existence of some fact or information which would satisfy an objective observer that the crimes of genocide may have been committed. And to that end, the prosecution submits there are indeed such reasonable grounds. For that, we make 3 submissions. First, that the case is indeed admissible before this court. Second, that the case is within the jurisdiction of this court. And lastly, there are reasonable grounds to believe that Mr. Grevas should be held criminally responsible as an effective military commander for the crimes of genocide committed by his forces. I will address Your Honors on the first 2 issues, while my co-counsel, Mr. Chong, will address Your Honors on the last issue. On to our first issue on admissibility. This case is indeed admissible before this court, pursuant to Article 17 of the Rome Statute. For a challenge on admissibility, the burden lies with the defense, who is bringing the challenge today, to prove that this case is inadmissible before this court, pursuant to the Appeals Chamber 2021 decision in the case of Yakatom. Your Honors, the prosecution posits that the most possible ground in which the defense may attempt to launch a challenge on admissibility is that the case is being investigated at the national level by the state of Honiton, pursuant to Article 17(1)(a). For that challenge to succeed, a case will be found to be inadmissible if it is being investigated on a national level. What this requires is for the defense to adduce evidence that the national level investigation is engaging in concrete, tangible, and progressive steps. This is a necessary threshold to uphold in order to ensure that the steps taken at the national level overlaps with the steps taken by this court. Now, the prosecution acknowledges that from paragraphs 17 and 18 of the facts, that a domestic military tribunal was set up and Mr. Grevas was placed on house arrest. However, the defense cannot rely on these sets of information alone to prove that the case is being investigated. As held by this court in its 2014 decision in Bagbo, the initiation of proceedings and the detention of the accused in and of itself is not sufficient per se to show that the case is being investigated. Because what is truly of concern is whether that investigative body was indeed taking concrete, tangible, or progressive steps into investigating Mr. Grevas's involvement in the crimes. This court has consistently held in previous cases the type of evidence required to discharge this said burden, which includes documentations of witness testimonies or documentation of site visits to the tragedies. On our current facts, the defense has not adduced anything to show that there was any attempted contact with key witnesses such as Mr. X, nor any IHRD personnel who have reported on this situation throughout the occurrences. Furthermore, the documentations of any visits to the tragedy site of Casteria were also absent on our current facts, and therefore the prosecution would say that the defense has failed to discharge the burden of proving that there was any investigative steps taken by the tribunal in which they assert was present. And therefore, Your Honours, the prosecution will submit that there are no such ongoing investigations taken by the state, and therefore this case should still be admissible before this court. Moving on to our second submission on jurisdiction. The prosecution submits that this case is indeed within the jurisdiction of this court. Jurisdiction, while not defined within the Rome Statute, has commonly been accepted to include territorial, temporal, and subject matter jurisdiction. Here, this court does indeed have territorial and temporal jurisdiction, notwithstanding that Honiton is a non-state party due to the UN Security Council's Resolution 2022, as can be seen from paragraph 1 of the procedural history, because pursuant to Article 13b of the Rome Statute, this court may exercise its jurisdiction contingent on whether a crime under Article 5 of the Rome Statute has indeed been committed, in which brings us to the most contentious point in jurisdiction, that of subject matter jurisdiction, namely whether there are reasonable grounds to believe that a crime of genocide that is within the jurisdiction of this court has been committed. And it's the prosecution's submission today that there is indeed such reasonable grounds. This is because the killings and the man-made famine do indeed meet the requirement for said crime of genocide under Article 6. To prove a crime of genocide by killing under Article 6a and by inflicting conditions of life calculated to bring about physical destruction under Article 6c largely requires two elements. First, the act of killing and inflicting said conditions of life must have affected an ethnic group. And second, there must be accompanying specific intention to commit said genocide, in which the prosecution will submit are both present on our current facts. Here, the Casterians are indeed an ethnic group. As you can see from paragraph 4 of the facts, they are referred to as an ethnic minority. Furthermore, they do also speak a distinct common language, pursuant to the 1998 ICTR's decision in the case of Kayashima that would qualify them as an ethnic group and hence caught under the genocidal provisions. Next, we do establish that there were indeed such required acts on the genocide provision that were indeed present. Here, the acts of killings can be seen from paragraph 12 of the facts, where 200 Casterians were killed after resisting arrest. This would satisfy the court that the act of killing has indeed been present. It was indeed present. Next, the infliction of conditions of life calculated to bring about physical destruction was also present in our current case. Such conditions of life include subjecting a group of people to a circumstance which would lead to a slow death. Here, said circumstances leading to such slow death was present via the famine. If Your Honours could see at paragraph 15, the police had forced the shutdown of all local businesses, making the locals unable to obtain food for sustenance. Furthermore, on that same paragraph, we can see that all local in-routes into the region were blocked off. In a mountainous country such as Honiton, if Your Honours could see from paragraph 2 of the facts, we would say that it's likely that food supplies can only enter the region via land. And therefore, by shutting down all local businesses and closing all local in-routes into the region, we would say that had effectively shut off all available food sources. Furthermore, Your Honours, this blockade was also for an extended period of close to 2 months, without any official aid or support. And therefore, we would say that the famine that was caused by this blockade was intended.
Sorry, I would like to make these 2 points clear on admissibility and jurisdiction. don't you consider that the fact to establish a military court to investigate on these facts is a kind of expression of political will from the government to accurately investigate on these facts first? And can you show us at any moment we have a dole special showing the intent, the intention to kill and to murder these people as a genocide? Looking at Exhibit 1, the messages between Mr. Gravius and Mr. Joly, don't you consider that Mr. Gravius is still caring about civilians and so on? Can you show us, I mean, the specific points showing that there was real intention to kill these people?
Certainly, Your Honours. To answer your first question, Mr. President, about whether the setting up of the military tribunal was sufficient, it is the prosecution's submission today that that is insufficient to show investigative steps, because what is truly of concern is whether that military tribunal was in fact actively investigating the case against Mr. Gravius. If Your Honours can see at paragraph 18, Mr. Gravius was placed on house arrest only shortly after his military coup, and this domestic military tribunal was not set up in conjunction with his arrest. And therefore, we would say that there are many reasons as to why this military tribunal was set up, and the defense still bears the burden to show that this military tribunal has in fact taken concrete steps into investigating into Mr. Gravius's involvement in the crimes of genocide. Next, onto your next concern, Your Honour, about whether there's specific evidence to show that the perpetrators had said specific intention. It is not Mr. Gravius's intention that is of concern here. It is the forces and the perpetrators committing said genocidal acts, which are the forces on the ground. In our present situation, Your Honours, due to the difficulty of adducing direct evidence of said intention, circumstantial evidence will suffice to provide this court said reasonable grounds to show such specific intention. From the ICTR's decision in Akayesu, which held that such circumstantial evidence will show the specific intention of said genocide. One factor held by the courts was the systematic targeting of victims on account of their membership to that particular group. Here, the forces had indeed targeted Castilians based solely on their membership to the Castilian ethnicity. Here, on the night of the 15th of July, 198 Castilian civilians were killed. This specific targeting is then further bolstered by the fact that at paragraph 14, we can see that one Mr. X, a person of Hanu ethnicity, was released independent of his allegiance to the CNN. And we would say that that would show that there was a specific intention to target the Castilians based on their ethnicity. Moreover, in the wake of that terror, while families were attempting to flee the province, they were stopped at that border checkpoint. This is analogous almost to the ICTR's decision in the case of Kayashima, where roadblocks were used to distinguish between the majority Hutus and the minority Tutsis for the Tutsis to be killed. In our present situation, the blockade similarly played such a filtration.
Excuse me, Counsel. What is the legal source for this course to use the jurisprudence of the ICTY and ICTR that you mentioned before?
Certainly, Your Honour. While we do note that this court is not bounded by the ad hoc tribunal's jurisprudence, we would say that pursuant to Article 21(1)(b), they would constitute principles of international law for this court to consider. And seeing as the facts in the Rwandan situation is analogous to our present situation, we would say that it is persuasive for this court to come to a decision based on those decisions. Here, Your Honours, even without such facts, we do see also that derogatory language was deployed during these genocidal acts. If I could point Your Honours to paragraph 30, if Your Honours are with me. Forces were cited chanting, "Castilians are cancer," while kicking pregnant women in the stomach as they cried and begged for their husbands' lives. Such derogatory language, coupled with the cruelty, demonstrated that it was an ethnically motivated nature of said targeted attacks. This also finds support from the ICTR's decision in Kakambitsi, where the use of derogatory language during said genocidal acts could evince said specific intention. Your Honours, one piece of circumstantial evidence in which the defence may attempt to rely on is that this was in the context of a security campaign. However, the prosecution would like to raise to the bench that the victims involved in this catastrophe is not just unarmed men, it was children, women, and pregnant women, no less. And we would say that there's no such security campaign which would involve said victim group. Thus, Your Honours, the first and most basic Nuremberg principle is that anyone who commits a crime under international law is responsible, therefore, and liable for punishment. Thus, having submitted that the defense will likely fail to show that the case is inadmissible and that the case is within the jurisdiction of this court, I'll now pass my time on to my co-counsel, Mr. Chong, who will show this court why Mr. Gravers should be held criminally responsible as an effective military commander for the crimes of genocide committed by his forces. Thus, unless I may be of any further assistance, I've come to the end of my submissions. May it please the court.
Thank you.
Mr. President, Your Honours, may it please the court. As earlier introduced, my name is Chong Kai-shen, and I continue the case for the office of a prosecutor. For the remaining time, I will show that there are reasonable grounds to believe that Mr. Gravers is liable under Article 28A of the Rome Statute. Article 28 of the Rome Statute enshrines command responsibility. It entails the principle that a commander can be held liable for the crimes committed by his forces if he had neglected his duties as a commander. Article 28A captures military commander or a person effectively acting as one, while Article 28B captures civilian superior. As a matter of law, a person cannot fall under both Article 28A and B. Today, the prosecution's case is that Mr. Gravers is liable under Article 28A. And to this end, we made 4 submissions. First, Mr. Gravers was the effective military commander of his forces. Second, Mr. Gravers had effective control of his forces. Third, Mr. Gravers should have known of the crimes being committed by his forces. And lastly, Mr. Gravers have failed to take all reasonable and necessary measures to prevent or repress the crimes. I begin with my first submission. We submit Mr. Gravers was the effective military commander. A person serves as an effective military commander if he had control over governmental forces, such as armed police units. This was stated by this court's 2009 confirmation of charges decision in Bemba.
Sorry, may I interrupt? Mr. Gravers,
yes.
Was he appointed commander, or did he appoint himself, declare himself as commander? Was he appointed officially commander, or did he declare himself as commander?
Yes, Your Honor, we do know that the facts does suggest that he had appointed himself as a commander. As such, he might not have de jure authority over the troops. As such, the prosecution is relying on the fact that he is an effective military commander. If I could just direct Your Honor's attention to paragraph 11 of the facts. And if I could check Your Honors are with me.
Yeah,
Your Honors will see that Mr. Gravers was the one who had initiated the alleged counter-terrorism campaign. Paragraph 11E also shows that he had ordered the heads of the forces to report to him on a regular basis. As such, Your Honors, Mr. Gravers was the effective military commander. Moving on to my second submission, the prosecution submits that Mr. Gravers had effective control of his forces. Effective control is ascertained through a multifactorial exercise. Factors such as ability to order troops engage with hostilities and abilities to ensure compliance with his orders are factors going towards effective control. And this was stated by this court's decision in Bamber. As mentioned earlier, Your Honours, Mr. Graves was the one who had commissioned the NDS, the SPG, and the police to engage with hostilities. Paragraphs 12 to 15 also show the scope of their operations. Moreover, Your Honours, Exhibit 1 also shows Ms. Jolie reporting to Mr. Graves pursuant to Mr. Graves' order at paragraph 11E. Specifically, Your Honours, Ms. Jolie was updating Mr. Graves regarding the status of the civilians being released upon capture. And this is indeed seen in paragraph 13 of the facts, when Mr. X, a civilian, was released upon arrest. As such, we say Mr. Graves did indeed have effective control over his forces. Turning to my third submission, the prosecution submits that Mr. Graves should have known of a crimes being committed by his forces. In determining whether a commander should have known of the crimes being committed, it is relevant for this court to consider whether there were information available to Mr. Graves, such that it will put him on notice and justify further investigation. And this was stated by this court's 2009 confirmation of charges decision in November. Your Honours, the prosecution wishes to point out that the whole incident in Hamilton had occurred throughout a span of several months. And during that span of time, there were IHRD reports and social media images indicating crimes occurring in Hamilton. Specifically, Your Honours, the social media images had drawn such a great international outrage that Mr. Graves himself had responded to at paragraph 16. However, Your Honours, Mr. Graves did not in fact investigate the situation and simply pushed the blame away from him. At this juncture, we note the defense might argue that Mr. Graves was entitled to rely on the report by Ms. Jolie as seen at Exhibit 1, and as such, he would not have the requisite knowledge of the crime. However, Your Honours, this cannot be the case. Considering the large amount of contradicting sources of information, we say that Mr. Graves was under an active duty to acquire information about possible contraventions of possible occurrences of crime committed by his forces. And we say that support could be found in this court's 2009 confirmation of charges decision in November. And furthermore, Your Honours, further support could be found back in the jurisprudence, such as the Nuremberg trials decision in the hostage case, where the court there has stated that a commander must acquire all relevant sources of information regarding the conduct of his troops, such that he can keep himself apprised of a situation on the ground. As such, we say, if Mr. Graves had in fact investigated the situation, he should have known of the crimes being committed by his forces. Turning to my fourth and final submission, Your Honours, the prosecution submits that Mr. Graves have failed to take all reasonable and necessary measures to prevent or repress the crimes. Mr. Graves did not put in place a proper monitoring system to keep himself apprised of possible international humanitarian law contravention. And the reports by Ms. Jolie did not indicate any number of casualties or the scope of operation by his forces. And even if assuming that the operation is indeed a counter-terrorism campaign, there is no signs of the number of casualties of CNF terrorists. Furthermore, Your Honours, even after the news of the crimes had occurred, Mr. Graves did not punish his troops or set up proper investigative bodies to investigate his subordinates. As such, Your Honours, Mr. Graves have failed in his commander duties to prevent or repress the crimes. To conclude, Your Honours, the seventh Nuremberg principle states that complicity in the commission of an international crime is a crime in itself. And we say, at the center of all these atrocities lies Mr. Graves. If Mr. Graves himself had properly exercised his commander's duties, all the innocent deaths of Castilians could have been avoided. Unless I could be of any further assistance to this court.
Excuse me,
Thank you.
counsel. Yeah, I have a question. I think that there's remaining time if I check. I have a question in relation to the knowledge of Mr. Graves in this particular case and how we can combine the specific knowledge required by Article 28 and the direct intent or the specific intent that is required by the crime of genocide. What is the position of the prosecution in this point in terms of, for example, using the should have known and at the same time the intent in relation to the crimes of genocide?
Your Honors, the prosecution is not submitting that Mr. Graves himself possessed the genocidal intent. As a matter of law, a commander himself does not need to possess the genocidal intent. It is in fact the troops on the ground that must have the specific intent. And this was stated by the 1996 Appeals Chamber's decision in Akeyetsu. What is relevant for Mr. Graves under Article 28A is that he must possess the requisite mental element of should have known, which I had earlier addressed this court on. This concludes the submission from prosecution. May it please the court.
Okay, Judge Seoane, is that okay for you?
Yes, thanks, Presiding Judge.
Okay, okay. We can move forward with the defense team, team 67. In the courtroom, team 67.
Mr. President, would you like to take appearances?
Yeah, you can go ahead.
May it please the court. Mr. President, Your Honors, my name is Hankins, spelled Hankins, initial N, and I appear with my learned co-counsel, Hardy, spelled Hardie, initial A, representing the defense in this matter. I will be making submissions on the first item of the agenda, speaking for 9 minutes, and my learned co-counsel will be making submissions on the final 2 items of the agenda, speaking for a further 16 minutes. We reserve 5 minutes for our rebuttal. May it please the court.
Okay.
May it please the court. Mr. President, Your Honors, the prosecution has characterized the case before this court as one of premeditated discriminatory intent. It is our submission that the conduct before the court must be viewed prospectively and with the court's purpose and function in mind, as a court of last resort and for only the most serious of international crimes. Anything that falls below the standard will undermine the court's role in the international community. In light of this, the defense makes 3 submissions in response to the prosecution's claims. First, that the case is inadmissible before the court. Second, that the case does not fall within the jurisdiction of this court. And third, that there are reasonable grounds to believe that Mr. Graves, as an individual, is not criminally responsible for the alleged genocide. The court need only be with us on one of these points in order to determine that the case does not proceed to the confirmation stage. Turning now to our first submission on the issue of admissibility, the defense agrees with the prosecution's legal tests and the standards that they've applied in order to determine whether a case is inadmissible before the court pursuant to Article 17(1)(a) of the Rome Statute. Here, the prosecution has submitted that there is no ongoing investigation by the nation of Hanatun, and they've relied on 2 key factors to demonstrate this. These are, 1, that the military court is not in and of itself an investigative step at paragraph 18, and 2, that the house arrest of Mr. Graves is not sufficient to establish an investigative step, also can be found at paragraph 17 of the facts. In doing so, the prosecution has isolated different elements of the state's investigation and concluded
Apologies, Your Honor. This is the coach of Team 67. I believe that my team's internet has just cut out. Would we be able to take just a time extension to fix this out on their end?
Okay. So it's a technical issue, right?
Yeah, their internet seems to have dropped out.
Okay.
I will try to coordinate with them remotely. Thank you.
Okay. Judge Tochilovsky.
Yes.
I apologize, Your Honors. My computer seems to be experiencing some difficulties. May I proceed with my submissions?
Okay, continue, please.
Which must be read in light of the principle of complementarity, referring to Article 17. As I was saying, in order to uphold the principle of complementarity, the case should be considered inadmissible if it satisfies the definition of investigation. The appeals chamber in 2013 in the case of Mathwara at paragraph 1 has defined an investigation as the taking of steps to ascertain whether an individual is criminally responsible for the conduct alleged. Therefore, the question is not whether the individual elements of the investigation can be considered investigative steps, but rather whether all the steps taken together are sufficient to demonstrate on the balance of probabilities that the nation of Hanatun is taking steps to ascertain whether Mr. Gravus is criminally responsible for the conduct alleged. And here the defense submits that all of the steps taken by the nation of Hanatun are sufficient to demonstrate the ongoing investigation of the same case. We point to 3 factors on the facts to demonstrate this. First, that the military court is a concrete and tangible investigative step. The prosecution here has argued that the establishment of the military court is not an investigative step. Contrary to the prosecution, it is our submission that the military court is an investigative step, and in fact, is recognized internationally as a fundamental investigative step for states conducting criminal investigations. This is supported by the International Committee of the Red Cross in their 2019 publication on guidelines on investigating violations of international humanitarian law. In their report, they state that making sure there is an independent and impartial body conducting the investigation is an internationally recognized and fundamental part of a criminal investigation, and the first responsibility of a state when it is conducting their criminal investigation, pursuant to Guideline 7. The establishment of the military court
Excuse me, Counsel, what is the relevant source, the legal source for this course to apply the report that you mentioned from the ICRC?
Here, the relevant source is that it comes from a well-recognized international body, and we are able to apply this. We are able to apply and extract the principles from this report as it is relevant in determining how the Rome Statute should be applied in the current case. And the principles of international law should be applied irrespective of the body that it comes from. Further, the prosecution has argued that the recommendations from high-ranking military officers at paragraph 18 have no apologies. I withdraw that, Your Honor. Here, the prosecution has further made submissions that the military court and the recommendation, I withdraw that, Your Honors. The second step and factor on the facts that establish that an investigation is ongoing is the continued detention of Mr. Gravus. Contrary to the prosecution, the defense submits that the continued detention of Mr. Gravus is an investigative step. The prosecution has argued that Mr. Gravus was arrested solely in connection with the military coup in paragraph 17. However, it is our submission that it is Mr. Gravus's continued detention until being delivered to the court at paragraph 18 that is demonstrative of the ongoing investigation necessary to prevent Mr. Grabus from fleeing.
May I interrupt, please?
Yes,
please.
Mr. Grabus.
On the point of the establishment of the military court as a concrete investigative body, I have one question. Why the authorities did not establish, a non-method, and instead they put in place a military court? Why a military court? One. I can see that this military court was established after Mr. Grabus was stepped down from power. Why Mr. Grabus himself did not, while he was on power, why he did not take all the necessary measures to investigate while he was on power?
Mr. President, it is our submission that Mr. Grabus they began the investigation of Mr. Grabus at the first instance that it was possible, which is after the military coup. The reason that the military court is established as a military court and the reason that characterization is important is because Mr. Grabus is a military commander and the military court is responsible for dealing with those in the military. The characterization of the military court, however, does not preclude its purpose and its intent to bring Mr. Grabus to justice. Further, the prosecution has referenced the pre-trial chamber's decision on the challenge to admissibility from Gago to argue that the arrest of Mr. Grabus is not sufficient per se to establish an ongoing investigation. Here, we agree with the prosecution that the arrest of Mr. Grabus is not sufficient in and of itself. However, this lends itself precisely to the crux of our submission, which is that all the steps taken by the national jurisdiction of Hanatun, namely the establishment of the military court, the continued detention of Mr. Grabus, and the recommendations from high-ranking military officials, analogous to witness testimonies pursuant to Article 2, Paragraph 40 of Mothwara, are sufficient on the balance of probabilities that the case is being investigated, because they collectively go towards ascertaining whether Mr. Grabus is criminally responsible. If there are no further questions, Your Honors, I defer to my learned co-counsel to speak on the final two items of these submissions. May it please the court.
Okay.
May it please the court. Mr. President, Your Honors, I make two further submissions. First, that this court does not have jurisdiction over the alleged conduct. And second, that Mr. Grabus cannot be held criminally responsible. I turn now to my first submission, which challenges this court's jurisdiction on the basis that jurisdiction ratione materiae has not been made out. Addressing the prosecution's contentions in order, my first submission has two limbs, that the elements of Article 6A and Article 6C have not been fulfilled. We note that for the defense to succeed, we need only convince this court that one element under these articles fail. Turning to the first limb of my first submission regarding genocide by killing pursuant to Article 6A. The primary submission we make in response to the prosecution is contending that deaths occurred as a result of genocidal intent. The most difficult part of the prosecution's case is establishing that killing was done with a desire to destroy the Castilian race. On this point, the prosecution has relied principally on three factors to establish specific genocidal intent. They are first, the alleged targeting of Castilians during arrests. Second, the Castilian deaths resulting from arrests. And third, the derogatory language used towards Castilians. With respect, these three factors, whether individually or taken together, fail to demonstrate reasonable grounds for believing the crime of genocide has taken place. Now, first, the prosecution's reliance on the standalone factor of Castilians being targeted by the NDS and SPG is incorrect as a matter of law. The targeting of a particular group in and of itself does not amount to genocidal intent. Intention must be to destroy the group as such, meaning destroying them as a separate and distinct entity, and not merely some individuals due to their membership in that group. This was held in the ICTY trial chamber of in Ulesic at paragraph 79. Therefore, the true question here is not whether killings targeted Castilians, but whether Castilians were targeted for the purpose of eradicating the Castilian race in whole or in part. On this factor, the prosecution submits the NDS and SPG specifically targeted Castilian men during their arrests. However, where the prosecution's argument here falls down is in their failure to take into account the context and therefore the true purpose of these arrests. Your Honours, what is important to the court's inquiry is the subjective intent of Mr. Gravis and the Hanu government. And this is clear from the express wording of Article 6 and the elements of crime. Now, in adducing the Hanu government's subjective intent, it is our submission arrests were only ordered to address the CNF terrorist threat. Your Honours, the CNF was a military threat. To substantiate this, I would point Your Honours to paragraph 7 of the case facts, where the CNF created a separate military force, which necessarily destabilized the national security of Hanatan. I would in particular note the final 3 lines of paragraph 7, showing that the CNF military branch was created with the purpose of resisting the government, illustrating that the CNF had an offensive and not defensive purpose. The court can then see at paragraph 9 of the case facts that the Hanu government understood that the CNF military force had violently attacked the Hanu military, burning 35 of their soldiers alive and killing 3 civilians. Where it was perceived by the Hanu government that the CNF posed a terrorist threat, any subsequent act to kill or destroy a militant threat does not amount to genocidal intent. This was held at paragraph 860 of the ICTY trial judgment of Popovich. Accordingly, Your Honours, the manner of the arrests must be viewed in light of this terrorist threat. The IHRD at paragraph 12 affirmed that individuals were only arrested for affiliations with the CNF. The precursor to any violence from the SPG and NDS was when suspected terrorist threats were resisting arrest. It was for this reason 200 men were killed, not by reason of their race. Further to the 86 deaths, this occurred only when individuals were fleeing and not because they were Castilians. This relates to the second factor relied upon by the prosecution. On this point, the prosecution relies heavily on the evidence provided by Mr. X at paragraph 13, where he, as a single witness, testified that he was released due to not being Castilian, as well as testifying to the SPG using derogatory language, which the prosecution submits as a separate factor. However, Your Honours, this chamber should proceed cautiously in assessing Mr. X's evidence. First, Mr. X's testimony is hearsay. It was told to the IHRD, who speaks to his testimony. At paragraph 42 of the trial judgment in Gabago, it was held for hearsay to be accorded any probative value, that the chamber be provided with adequate information regarding the reliability and credibility of the original source. Here, this was not possible as Mr. X is anonymous hearsay. The trial chamber at paragraph 9 of Natanga reinforced that it is well established that no reasonable trier of fact can draw a conclusion solely on the basis of anonymous hearsay. No other evidence corroborates Mr. X's claims, and as such should not be accorded significant probative value where the prosecution relies on his evidence to substantiate claims of derogatory language, as well as pregnant women being kicked, as well as individuals being released when they were not Castilians. Ultimately, Your Honours, the allegations here do not rise to the threshold of genocidal intent. Turning now to the prosecution's allegations regarding Article 6C and the famine in Castilla, this speaks to the second limb of my first submission. The primary submission we make in response here is that the blockade and closure of businesses was not intended to bring about the physical destruction of Casteria. The prosecution cannot point to any evidence that shows this court that the famine was an intended consequence of the lockdown of Casteria. In the context of a perceived terrorist threat, putting a region that the terrorist group was known to operate in is a step to stop this terrorist group from expanding. This was the intention of the Hanu government. It was by no means a novel response, given in 2015, the state of Belgium, in response to a terrorist threat, put its capital into a similar lockdown to the one on these facts, including closing businesses and travel routes. Paragraph 15 of the facts states that the government only put Casteria into a state of lockdown due to the likely and severe consequences a CNF attack would have. The prosecution cannot prove that the famine was an intended consequence of the lockdown, let alone a consequence intended to destroy the Casterian group. And necessarily, these actions do not rise to the threshold of genocidal intent. Your Honours, even if this court finds that it does have jurisdiction, our final submission is that Mr. Gravis cannot be held criminally responsible. The prosecution has presented 3 arguments to substantiate their claims under Article 28A, and I will address each of these in order. The prosecution first argued that Mr. Gravis possessed effective control. As a preliminary note, Your Honours, effective control is a high threshold, not simply satisfied because Mr. Gravis was the commander-in-chief. Here, the prosecution has relied on 2 factors to substantiate effective control. First, they rely on a lack of disobedience, as well as the ability to give orders to troops. In relation to the lack of disobedience, we make 1 submission. We submit here on the facts, there was disobedience regarding the reporting mandate at paragraph 11E. At Exhibit 1, lines 3 to 6, in response to Mr. Gravis's request on an update on the situation in Casteria, Ms. Jolie only tells Mr. Gravis that all civilians were being released during arrests. However, this was not the truth, given civilians were being detained, as well as Ms. Jolie failing to mention the deaths occurring. As such, this was not an accurate report of the situation in Casteria and shows that Ms. Jolie, who sat at the top of the chain of command of the NDS, was disobeying the reporting mandate issued by Mr. Gravis. In relation to the...
May I interrupt?
Yes, Mr. President.
As you just mentioned Exhibit 1, looking at Exhibit 1, Mr. Gravis has a military commander. You don't think that he should have taken additional measures to monitor and control the operations under his command? Only these messages, do you think it is enough to control as military commander the operations he himself ordered? What do you have to say? As military commander, he has a certain responsibility. And do you think that he can only control and monitor the operations under his control only by exchange of messages? What do you have to say about that?
Mr. President, we submit that this matter has been discussed in international jurisprudence. And in this regard, what the courts have held is that while there is a general obligation on superiors over their subordinates, a superior's mere negligence in remaining informed is insufficient to result in liability. Instead, liability only arises if a superior fails to act in spite of already knowing something relating to the crime, which gave them reason to inquire. And this was held in the ICTY case of Celebici at paragraph 226, and also emphasized in the 2018 appeal of Bemba. This leads me to the prosecution's second argument here, that Mr. Gravis had the requisite mens rea. In this regard, the prosecution only argues that Mr. Gravis should have known of the shootings in Casteria as well as the famine. In response to the prosecution submissions relating to Mr. Graves' knowledge of the shooting of 286 men, we submit here that contrary to the submissions of the prosecution, from Exhibit 1, there is no reason Mr. Graves should have known of deaths occurring during arrests. What the prosecution submissions has failed to recognize is that these texts make no reference to violence, unrest, or any violations of international law. In fact, Ms. Joly tells Mr. Graves that the situation is under control, and that can be seen at line 4 of Exhibit 1, showing that Mr. Graves had no reason to make further inquiries. And we agree with the prosecution that this is the standard for should have known. Now, in response to the prosecution's submissions relating to the famine, we submit that Mr. Graves had no reason that he should have known on the basis that, to Mr. Graves' knowledge, he knew the cause of the famine. In his mind, to his knowledge, his subordinates did not cause the famine, and rather the famine was caused by economic issues. Indeed, Mr. Graves had been taking steps to address the economic issues seen at paragraph 16 of the facts. As such, given Mr. Graves believed he knew of the cause of the famine and was taking steps to address this, he had no reason to make further inquiries as to its true cause. Finally, turning to a duty to prevent. The duty to prevent only arises if the prosecution can prove Mr. Graves both had effective control and he knew of the crime of genocide being committed. However, as previously submitted, Mr. Graves lacked effective control and did not know of the crimes occurring, and as such, the duty to prevent the crime never arose. Mr. President, Your Honours, that concludes the submissions on behalf of the defence. Considering the case facts presented, we seek that this matter does not proceed to the confirmation of charges stage, as jurisdiction and admissibility of this case has not been established. If I may be of no further assistance.
Thank you, Team 67. Thank you. Now we move forward with the rebuttals. The prosecution team, you have 5 minutes for rebuttals.
Mr. President, Your Honours, the prosecution has 3 points in rebuttal. First, in relation to admissibility. Second, in relation to jurisdiction. And lastly, in relation to the element of knowledge. On the first issue of admissibility, the defense argues that setting up of a military tribunal is in and of itself an investigative step, and they relied on the Red Cross report to substantiate their proposition. And as queried by the bench earlier, they did not mention which provision under Article 21 are they allowed to bring this this Red Cross report. And in fact, Your Honour, as you can see from this court's jurisprudence in the 2014 case of Bagbo, setting up of that investigative tribunal is in and of itself insufficient. And further, they said that we disjuncted the 2 investigative steps, namely keeping him under house arrest and setting up the tribunal. However, in the case of Bagbo, these 2 steps were also present, and the court found it was insufficient for the defense to solely rely on.
Excuse me, sorry to interrupt. Which Bagbo case are you mentioning? Simon Bagbo or Laurent Bagbo?
Simon Bagbo, Mr. President,
okay.
The 2014
okay.
case on admissibility. Yes, Your Honor. Next, moving on to the rebuttal on jurisdiction. First, the defense challenges the credibility of the IHRD report, stating that this court cannot rely on it, and they relied on 2 trial chamber decisions. However, Your Honor, it is to be reminded at our current stage, we are at the pre-trial chamber stage, which only requires that of reasonable grounds. And therefore, Your Honor, this court in its trial chamber decision in 2016, in the case of Taganda, held that at the pre-trial chamber decision, it only requires some fact or information without the need to assess the witness's credibility nor reliability. This is in order to progress the case to the confirmation of charges stage, where more evidence can be adduced in more detail. And therefore, the IHRD report should still be relied by this pre-trial chamber. Next, the defense further argues that the specific intention is that of the government, and that is what we should be concerned with. However, they have erred in the law. From the ad hoc tribunals from the 1998 ICTR decision in Akayasu, 1999 ICTR decision in Kayashima, 2010 ICTY decision in Popovich, and this court's 2010 decision in the case of al-Bashir, it has consistently been held that it is the perpetrators on the ground in which has to possess said specific intention. And therefore, honest, having submitted that the perpetrators on the ground had possessed said specific intention, we would say this court has subject matter jurisdiction. And lastly, Your Honor, on to the point on knowledge. The defense argues that the defense relies heavily on the ad hoc tribunal's jurisprudence that there is no duty to investigate. However, in the ad hoc tribunal's jurisprudence, they rely on the mental element of had reasons to know. In our present case, we rely on the Rome Statute, in which states should have known. And therefore, Your Honors, this court had held that there is an active duty on the part of the commander to acquire said information to satisfy this should have known standard and the reports must include those of his troops, regardless of the availability of information to him. This was held by the 2009 confirmation of charges decision in the case of Bemba. And therefore, Your Honors, we would say that he still should be deemed to have known of the crimes committed by his forces. With that, Your Honor, the prosecution will urge this court to commit this case to the confirmation of charges stage, to continue this search and this process to serve justice for the innocent victims involved in this catastrophe. This is to punish the people truly responsible and to put an end to all impunity. Thus, unless I may be of any further assistance, I've come to the end of my rebuttal. May it please the court.
Thank you. Judge Tochilovsky and Judge Seoane, do you have any question to the prosecution team?
No.
No, Mr. President, thanks.
Okay. Now, rebuttal for the defense. Defense team.
Yes, Mr. President. May it please the court, Mr. President, Your Honors, the defense submits 4 points in sir-rebuttal. First, on admissibility and the characterization of the military court. As a preliminary note, we would submit to this court that Article 21 of the Rome Statute allows this court to have regard to the guidelines of ICRC, but more particularly to the rebuttal submitted by the prosecution. It is not the defense's submission that the military court in and of itself is sufficient for an investigation. Rather, we submit an investigation is more than the sum of its parts. Where the prosecution points to any one step in isolation as insufficient to demonstrate on an ongoing investigation, we submit that all steps taken together by the national jurisdiction of Hanatan are collectively sufficient. Namely, the establishment of the military court, the recommendations of high-ranking officials, and the continued detention of Mr. Gravis. On the balance of probabilities, these form an investigation that collectively goes towards ascertaining whether Mr. Gravis is criminally responsible for the alleged conduct. Second, the prosecution submits that the pretrial chamber cannot consider the credibility of witnesses at this stage of the in this chamber. Your Honors, this is an error of law. In the 2007, in the pretrial chamber 1, in the hearing of the prosecutor against Dalila, at paragraph 101, it was held that anonymous hearsay may only be used to corroborate other evidence. In the pretrial chamber, they had regard that the only way that the pretrial chamber can award probative value to anonymous hearsay is where the prosecution can substantiate it with the original sources, credibility and reliability, And given this is not possible for anonymous hearsay, it is appropriate for this chamber not to accord Mr. X's testimony probative value. In any case, the prosecution has submitted that the defense challenges the IHID report. However, this is a mischaracterization of our submissions. We submit that Mr. X's testimony himself has not been Apologies, Mr. President. My internet has cut out. I will continue on my co-counsel's computer. As I left off, in the case of Al-Bashir in 2009, in the warrant of arrest decision, the mental state of mid-level superiors and low-level physical perpetrators is not required to determine genocidal intent. Accordingly, here, the prosecution has erred in the law, as it is only useful to infer intent and not a requirement. Fourth, the prosecution has made submissions regarding the should have known standard. However, in this regard, no new submissions has been made, and we stand by our previous submissions. Your Honours, this concludes the sir-rebuttal of the defence. If I may be of no further assistance, may it please the court.
Thank you. Thank you to both teams, defense and prosecution. Now, organizers, can we go to deliberation room?
Dear judges, dear team members, I will now move you to the deliberation room and the later two different breakout rooms. As soon as the judges have found the verdict, I will let the team members know. Thank you very much. He's presiding judge. The session can now be resumed.
Can you hear me? We are in the court room. Okay. Teams and organizers, the panel conclude with his deliberation. Judge Seoane will give general comments and observations. And me as presiding judge, I will give the name of the winning team and the best speakers.
Thanks a lot, Mr. President. Well, first of all, I want to congratulate both teams. It was a very difficult decision for this bench. The arguments, the structure, the knowledge of the facts was really impressive. You have identified some key aspects both for the defense and for the prosecution. We know that was not an easy case, and we are really delighted by the narrative of the case and the different facts involved. I will give some general comments that maybe you can use for next rounds to have in mind, or even for your career as professionals. First of all, I want to mention that we really like the fact that you try to engage with the bench in terms of how you answer the questions, and also the fact that you are not reading all the time. Of course, you had your notes, and this is very important as we have in real life. But yeah, I mean, it's important to engage visually with the bench, so that's something like very important. Also, how you structure the facts and also how you structure the argument, so the methodology that you would take through the presentation that give us to us the possibility to know what is coming next, no, and what are the main arguments for each specific point. I would say that it's quite important because of course we would like to know as a bench, we want to know what are the different sources of what you quote, or the importance of the relevant aspect of what you quote. So I would say that always is important to include in your speech, like directly, so you avoid questions from the bench in terms of what is the relevant of specific sources. The same with, I mean, we know that sometimes the courts have maybe one case with the same name for as one of the questions were related. So have that in mind, that maybe it's important to identify clearly what a specific case we are referring, if there's especially two accused with the same surname. And at the same time, the importance of anticipating arguments of the prosecution or the defense, depending on the case. That's something that will also save time also for understanding why you are taking that point. So those are my general comments. Congratulations again. It was like a very rich session for both sides. And the last thing that I wanted to mention is I want to congratulate you also for the effort. We know that having this type of sessions online is difficult. We expect some technical problems, but no worries, because we know that can happen in real life, so it doesn't affect us in our decisions. So yeah, have that in mind, because we identify the knowledge that you have and how well you manage the hearing.
Okay. As Judge Seoane said, the two teams were wonderful. I would like to congratulate the two teams for the effort made and for the good presentation and arguments. I'm sure that this will be very useful for you in the future of your career. Unfortunately, we are obliged to select one winning team, as the rules of the Moot Court indicates. And for this hearing, the winning team is the prosecution team. And the first best speaker is the first speaker of the prosecution, Mr. Xia. And the second best speaker is the first speaker of the defense, Mrs. Ankins. Thank you. We thank everybody. Thank you, Mr. and Mrs. Judges. That's it.
Thank you so much, Mr. President.
The International Criminal Court is now closed. You may leave the courtroom at any time. The judges, thank you very much for taking your time, and I wish you all a pleasant day.
Thank you.
Thanks for the